following recent developments and the COVID-19 crisis that's currently taking the country by storm, it was thought that Seeker we'd try and continue to support our members and support our members' development during this time through our seminars program. Now, many of you may have attended some of our seminars that take place all over the country in our different regions. We do tend to focus on contractual and commercial awareness seminars and others on good practice. But today we are grateful, very grateful to Geraldine Fleming of Driver Tret, who currently provides an excellent seminars service for our Northwest members. And she's put today's seminar together and has agreed to trial this online. The response to us has been fantastic. So hopefully this is the start of many short webinars that we can put together to help provide CPD and ongoing support to people who might be working from home or who've maybe been furloughed during this time. Now, one note regarding furlough, as part of a condition of furlough, if people have been furloughed from their positions, is that companies cannot require you to undertake training. But if it's something that you choose to do so as part of your CPD, then that's absolutely fine, and we welcome you all to the call. So thank you for your patience that we may need. As we've said, this is our first webinar that we've run today. If there's any technical issues, please bear with us and me, indeed, as it's very likely to be my fault. If viewing this on a mobile or a laptop, you should be able, there is a chat function where you should be able to make comments or ask questions. So if anyone's got any questions, there will be a question and answer session at the end. So if you'd like to write these down, please put them in question format with a question mark at the end, and then we can distinguish those and then hopefully publish some at the end. For Geraldine to on and send out. There will be a little survey at the end, just a couple of questions just about how you found the webinar itself, joining in, how relevant it's been. So if you could just take a few seconds to answer those, that would be fantastic. And also after the seminar, we will send an email along to you, and that certificate that you can use just to say that you've attended, and there'll also be a feedback button on there. Please comment on it. You could think of any topic that Polly is interested in the future. That would be fantastic. So thank you very much, and without further ado, I'll pass you on to Geraldine. But if anyone does have any questions, please.
Hello, Gemma, can you hear me? Gemma, I can't hear you. Can you still hear me? Okay, I'm going to do what Gemma did a couple of minutes ago. Could somebody add into the chat whether you can actually hear me clearly, please? Excellent, right. I've had some yeses there from the audience. Brilliant. Okay, so hopefully everybody can see my starter screen. I want everybody to take great note of the fact that I've specifically put the date on this particular presentation, because the guidance and rules and regulations and legislation is changing all the time. Okay, so definitely 2nd of April. I'm also very glad that we didn't run this yesterday, because it might have been seen as partly an April Fool's joke. But anyway, the first few slides within the notes, they are a little bit of marketing about the firm I work for, which is Driver Tret. So hopefully you can see on the screen now that we provide support to the engineering and construction industries it serves from start to finish. So you can see there's some typical parts of the industry that we work in, such as infrastructure, marine and offshore, utilities and process and industrial. In terms of the group, we are the market leader in expert witness, planning, commercial, technical and dispute avoidance, and importantly, dispute resolution as well. We were established in 1978, stock market listed, and there's over 500 of us who work in a network of offices worldwide. There's three main parts of the business. From the left, we have driver project services, so we can effectively provide quantity surveyors, project managers and planners on the projects that you're working on if you have a short, medium or long-term need. The part of the business I work for is driver tret, and we effectively provide a contract advisory service as well as commercial and contract management, planning, programming and schedule services, and then finally dispute resolution services. On the right-hand side, you can see our expert witness division, which is Dialis. We provide quantum and delay analysts in arbitration and litigation hearings, and we also have a technical division as well. And certainly one of the growing areas for our technical division over the past, probably the past year, of course, has been Grenfell related issues. If you are inspired after the seminar, you can actually download our Driver Tret Digest, and that's available either from our website or by emailing our marketing department. A little bit about me on the next slide. I am sure that I have some friends amongst the 92 of us who are on the seminar today who are also quantity surveyors, so a shout out for the quantity surveyors. Chartered quantity surveyor, I am ex-Balfour Beatty. On leaving Balfour's, I then joined a consultancy. I completed my law degree in 2002 and my solicitor's exams in 2004, and I've worked in construction claims consultancy for over 20 years. We're going to start just by having a look at some documentation that I have come across over the past couple of weeks. This has been chosen completely randomly. And I'm sure some of you within the presentation, the people that are attending, you will have seen headlines like, Michael Gove has said construction workers can go to work today, even though they aren't on the key worker list. That's straight from the Manchester Evening News. Alternatively, we've got The Guardian, 25th of March, UK construction firms split over the coronavirus shutdown. Top right-hand corner, we can see there, Business Secretary tells construction to continue critical contribution. Nice bit of alliteration there from that particular editor. Building Magazine, not so long ago, coronavirus, the major construction firms shutting their sites. And it is an enormous issue for the industry about what should they do. Should they close the sites or should they keep them open? Interestingly, I am sure that some of you in the past have actually come across this ability that we now have as citizens in the UK to sign a petition. And there is actually a petition about closing construction sites because of COVID-19. I have to admit that I wasn't so impressed by the numbers who'd actually signed up. We've only got 4,347 signatures on that particular petition. Out of interest, I'm sure some of you might want to have a guess at the petition, which is for making hedgehogs a protected species. That's one specifically for Gemma. That has had 43,000 signatures. Or making pet crime a specific offence has had over 13,000 signatures. And the one I thought was the best of all, legal rights for ancient trees, has had 5,700 signatures on it. So the petition about closing construction sites is a little bit down the scale in terms of people in the industry actually signing up to do something about whether the site should be closed or not. Looking at some government guidance next, I think probably the link that I've clicked on most hasn't been Joe Wicks, but has actually been this piece of information from the government. Now, I'm going to emphasize the words in blue. It talks about full guidance on staying at home and away from others. And certainly I have been involved in huge debates in relation to this wording. And it says in the government's own guidance, and it is still live guidance today, it says employers who have people in their offices or on site should ensure that employees are able to follow Public Health England guidelines, including, where possible, maintaining a 2-metre distance from others, washing their hands with soap and water often for at least 20 seconds, or using hand sanitizer gel if soap and water is not available. The amount of debate in the industry about the phrase where possible is extraordinary. We have a very recent campaign. I don't know whether any of you saw this yesterday on Twitter. Government UK saying anyone can get it. Coronavirus, stay home to help us save lives. And then, of course, a lot of you, I'm sure, on LinkedIn or otherwise, have seen Alok Sharma's letter from the BEIS, it's part of the government, end of March, which said, government has advised that wherever possible, again, that phraseology, people should work at home. However, we know that for many people working in construction, their job requires them to travel to their place of work. And they can continue to do so. That is consistent with the Chief Medical Officer's advice. And that really has left construction in an absolute confusion in terms of what they should do. What I will point you to are the excellent Seeker briefings, obviously with this being a Seeker seminar, and that is being updated. The Seeker homepage is being updated daily with different briefings, and I've put some examples there on the screen in front of you. To give you an example of the correspondence that contractors are facing at the moment, I've put on the next screen some typical communications. On the left is a letter that admittedly I stole from Twitter. And you can see there, it talks about the advisory restrictions being not yet legally binding, construction still being a permitted activity, and we've got some reasons for that. And then it says, therefore, unless instructed to the contrary or legally required to stop, you are, as far as possible, to maintain a business as usual approach. That's a contractor to a subcontractor letter saying, carry on. On the right-hand side, we've got a letter again, main contractor to a subcontractor, effectively saying, in this particular instance, we've closed the site because of health and safety. So the two contrasting letters they couldn't be further apart. I'm not going to give guidance as to whether you should stay open or you should be closed, because effectively it's a moral rather than a contractual decision for each and every firm, and there will be different circumstances in relation to every single job. What I will point out, though, is I have been watching Andy Burnham on Twitter. Of course, he's the Mayor of Manchester, and him, along with the Metro Mayor in Liverpool and also Liverpool City Region, they wrote a letter yesterday to Alok Sharma and to Matt Hancock, basically saying that they were unhappy with the position at the moment in relation to construction sites and how they were being operated at the moment. I've quoted an extract from that particular letter. Can I advise you all that it would be a really good idea to actually download and have a look at that particular letter? Because again, it emphasizes the words that I looked at before, which is the where possible. Okay, so that's just a little bit of background and some of the issues that are facing the industry. So let's get down in terms of having a look at some of the particular wording that you may be coming across in some of your contracts. And certainly the phrase that you will find in the vast majority of articles that are being written at the moment on this subject is this phrase: force majeure. So I have to admit, I've never done this on a webinar before, but here goes. We're going to have a survey. So I am hoping that the right Gemma, I'm hoping that the right survey is about to come up here. Hang on, here we go. So hopefully you can see on the board in front of you, it says, do you think that the coronavirus crisis is a force majeure event? I won't be quoting what anybody answers at this point. If you can answer yes, no, or don't know and press submit now, that would be very, very helpful. So I'll just give you a couple of minutes to do that. Okay, so hopefully everybody's had a go at that particular survey. I'll come back and ask Gemma in a minute what kind of results we got on that particular poll. So force majeure, let's go back. Here we go. We didn't get many people voting there. We got one. So hang on, the votes are coming in. Oh, that definitely looked to me, I'd say pretty overwhelmingly yes. That's 50 out of 96 people who voted. And then the don't knows at 19, I think that's as valid an answer as anybody else's. And then the no at 10. So I'd say, yeah, we have the yeses in terms of the force majeure event in relation to that particular survey. So back to the presentation then, and let's just have a look at I'll say the legal background to force majeure. I'll say unsurprisingly, in relation to the legal system that we have in the UK, there is no clear legal definition of force majeure. You cannot go to a particular Act of Parliament and find out what force majeure means. It's not defined in JCT contracts, even in terms of the unamended version. And of course, actually, NEC doesn't use that phraseology either. We have got some things that can help us out. If I go back to 1920, there's a case called Lebopin and Richard Crispin and Company, which confirmed that force majeure was all circumstances independent of the will of man. And then it continued, it included that war, inundations, and epidemics are cases of force majeure. Now, this particular case, it was all about salmon fishing. So absolutely nothing to do with construction. And it was about the availability of tins to pack the salmon. In this particular case, the company were not able to successfully run the line. It was a force majeure event, so they lost. But that probably is going to be a useful definition for us. Inundations refers to flooding. It's just an old-fashioned word. I think the phrase epidemics here is useful because, of course, we're in a situation which is now a pandemic, which is a further step. Interestingly, one of my colleagues listened to a webinar a week ago, and it was given by the insurance industry. And one of the panelists in relation to this particular seminar said that it wasn't a force majeure event. I have to admit that all of the articles that I have seen on this would be hinting that this is a force majeure event. However, I will caveat it with it's going to depend on the circumstances surrounding the time that you signed your contract and what your contract actually says. One of the big legal textbooks that I'm sure is about to probably go out of print with people buying it is by Ewan McKendrick, 1995, and it's called Force Majeure and Frustration of Contract. And in that, there is this very nice quote. It says, "Thus, with some hesitation, we might say that in English law, an event will be a force majeure event if it constitutes a legal or physical restraint on the performance of the contract, whether or not occurring through human intervention, although it must not be caused by the act, negligence, omission, or default of the contracting party, which is both unforeseen and irresistible." Irresistible, absolutely nothing to do with attraction, but actually here in this context, it means unavoidable and insurmountable. However, the word I want to concentrate on is actually the word unforeseen. That's so important in relation to what we're going to look at later. So, how does NEC3 deal with coronavirus? I am specifically not looking at NEC4 today. There are some little tweaks in relation to that particular update, just looking at NEC3 because I know that that is still the most commonly used contract in relation to the engineering industries. It's always nice to start with a bit of a cuddle. And of course, we have in the lovely NEC contract, clause 10.1, which says, "The employer, the contractor, the project manager, and the supervisor shall act as stated in this contract and in a spirit of mutual trust and cooperation." Those two letters I showed you before, they do not look like a spirit of mutual trust and cooperation to me in any way at all. You can see I've got part of the text in red and part of the text in blue. I haven't in this presentation gone through the case law in relation to this particular clause, but in summary, the courts have said that the bit in red is more important than the bit in blue, so that the parties, the project manager and the supervisor, shall act as stated in this contract. Very, very important to keep that in mind in relation to communications and notifications, which is what we're going to go through in relation to the next few slides. So you can see on the screen there, clause 13.7. I will read this out slowly. It says, "A notification which this contract requires is communicated separately from other communications." This is a hugely important clause, and it is quite often overlooked by both parties. When you are sending communications, you mustn't mix them up. Each compensation event notification must be sent separately from each early warning and separately from each other CE or separately from each other early warning. You cannot bundle them together. Otherwise, you will fall foul of 13.7. And importantly, you cannot bury this notification in a progress report or a program, because of course that contains other information as well. So notification in a progress report or a program is not sufficient. You need to check your contracts and make sure you're clear as to whether you can or you can't send it by email, you can or you can't send it by post or by hand, but importantly, taking notice of 13.7. Another important clause here, of course, is the early warning clause. And again, I'm sure most people who are on the seminar today are aware of the early warning clause. The contractor and the project manager can give an early warning by notifying the other as soon as either becomes aware of any matter which could increase the total of the prices, delay completion, delay meeting a key date, or impair the performance of the works in use. The contractor can give an early warning on any other matter which could increase his total cost. It's the project manager's duty to then enter early warning matters in the risk register. You don't need an early warning if you've already given a compensation event notification. Remember, that's the unamended clause. Okay. Do I think you should have already have given an early warning? Yeah, absolutely. Remember, looking at the bullet points on the screen, yes, we're talking about increasing the prices and delaying completion. Don't miss out the notification about delay of a key date. You should be aware as to whether your particular contracts do have key dates, and make sure your notification also refers to those key dates if they're going to be delayed as well. The only other thing I want to say in relation to early warning notices, of course, is that if you don't give the early warning, there can be a consequence that the project manager can value the compensation event as if you had given an early warning. So in other words, if the project manager could have made savings because of receiving this early warning, and your delay in issuing an early warning or failure to issue means that the PM hasn't been able to make those savings, that could form part effectively of a reduction in the amount of money that you're entitled to. So make sure you're keeping an eye on these early warnings. In the NEC contract, there's two other main clauses that I want to look at. Clause 19.1 is generally referred to as the prevention clause. And again, I'm going to read this out. It says, if an event occurs which stops the contractor completing the works, or stops the contractor completing the works by the date shown on the accepted programme, and which neither party could prevent, and an experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it, the project manager gives an instruction to the contractor stating how he is to deal with the event. I am just wondering how many project managers have actually read this particular clause, realised that, I'll say potentially, because of course all the contracts are different on this, that this COVID-19 coronavirus event has happened, and actually that it is their duty to give an instruction. The information I'm getting back from the companies I work with is that project managers generally aren't giving instructions in relation to this matter. The other clause we need to have a look at here is clause 60.1. And of course, clause 60.1 gives us a list of reasons for which the contractor can claim effectively a compensation event, whether that's time or money related. Looking at 60.119, so this is the very last item on that list, it says that item 19 is an event which stops the contractor completing the works, or stops the contractor completing the works by the date shown on the accepted programme, so the same phraseology we had before, and which neither party could prevent. An experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it, and is not one of the other compensation events stated in this contract. Couple of things to point out. This event must stop the contractor completing the works. So in other words, there has to have been an effect on the programme, otherwise this doesn't come into play. Also, what I would hope that you would have in place is an accepted programme. In some instances, you may be on a project where, as a contractor, you are giving your updated programme to the project manager, and they actually aren't coming back and either critiquing it, coming up with reasons or changes, nor are they actually accepting it. As a contractor, what you must continue to do is provide those programmes in line with clause 32.2. So that would be normally monthly and whenever a compensation event happens and whenever the project manager requests a program. So you want to be in a situation where there is either an accepted program or that there should have been an accepted program, but for the project manager's failure to actually do the duty that is set out in the contract for him to do. So very much program related. I think we would probably all agree that it would have been difficult for the parties to have prevented this issue, short of almost locking people in the site for a period of time and saying, well, you're fine, it's not affecting our site. I can't imagine that any estimator at the contract date would have brought up coronavirus as an issue. But importantly, item 3 is not one of the other compensation events stated in this contract. And what I do want to point out to you is that this whole issue does not solely revolve around the prevention clause. Actually, some of the other clauses in the contract might instead be more useful to you. So for example, item 1 in that compensation event list is a project manager's instruction changing the works information. Item 2, an employer failing to give access to or use or part of the site. An instruction from the project manager to stop or not to start any work. Item 18, a breach of contract by the employer, which is not one of the other compensation events. You can see the note at the bottom there, possibly others as well. Again, you've got to look project specific and of course, look at your own individual contracts as well. Another clause that I am going to point out, though, which again has been an issue of huge debate, both internally within DriverTret and externally with our clients, has been the subject of X2. So X2.1 says, a change in the law of the country in which the site is located is a compensation event if it occurs after the contract date. The project manager may notify the contractor of a compensation event for a change in the law and instruct him to submit quotations. If the effect of a compensation event, which is a change in the law, is to reduce the total defined cost, the prices are reduced. And I'm asking almost the $1 million question there for the people who have got X2 in their contracts. Has there been a change in the law yet? So my review of the legislation, and in particular the COVID-19 Act of Parliament that has gone through, my view is that there has not been a change in the law. However, there has been lots and lots of changes in guidance, okay? Guidance in relation to the 2 meters where possible. But as it stands, I'm going to say at 1 o'clock today, because who knows what's happened in the last half an hour. As it stands today, there hasn't been a change in the law. And I will say yet, because that might well happen. That remains to be seen. Moving on to another clause that, again, I'm sure that the vast majority of people on this seminar are very, very familiar with, which is 61.3. If I was only allowed to choose one clause to look at in a seminar, it would be this one if the seminar was about NEC contracts. 61.3 says, the contractor notifies the project manager of an event which has happened or which he expects to happen as a compensation event if the contractor believes that the event is a compensation event and the project manager has not notified the event to the contractor. If the contractor does not notify a compensation event within 8 weeks of becoming aware of the event, he is not entitled to a change in the prices, the completion date, or a key date unless the event arises from the project manager or the supervisor giving an instruction, issuing a certificate, changing an earlier decision, or correcting an assumption. You can see from my beautiful red box there, almost with the flashing lights around it, this is a condition precedent clause. If you fail to give the notice, you will lose your rights to claim time and money. Also, you will have a potential exposure to liquidated damages as well. Beware, the notification period in the unamended contract is for 8 weeks. I see that changed regularly down to 4 weeks and even lower for subcontract notification as well. I also see another change, which is if you look 3 lines up from the bottom, you can see the words key date. Sometimes I see the rest of the text being deleted there, meaning that the contractor or subcontractor has a duty to notify everything, even if it is a PM decision. So you need to be aware of your specific Z clauses on this particular issue. This notification issue, certainly a question that I have got, is when did we become aware of this COVID-19 coronavirus issue? Well, certainly China was aware of it in December 19. We started seeing things in the press, probably odd news reports, maybe mid-January. Certainly by the start of March, the press coverage was certainly gaining momentum. The World Health Organization on the 11th of March 2020 made an announcement that this was a pandemic. I have to say that that is a key date for me. The Prime Minister started the briefings on the 16th of March 2020, and of course we had the Prime Minister's address at 8:30 p.m. on Monday the 23rd of March. I would want all of you to look at every single contract that you or your firms are involved in and check the notice and ask yourselves the question, have you already failed to notify in time? I would imagine that for the jobs that you're currently working on, I think probably you will have done the notification. However, the issue I would have is for those guys who are working on an off-site basis. So in other words, maybe you're doing design off-site before you start on the site. Did you give the notices there? Now, I have just spotted a really good question, and it's a good one to answer at this point. Somebody has asked, does an early warning notice constitute a 61.3 notice? My answer to that is absolutely not. An early warning notice is completely different from a 61.3 notice. So if I look in hindsight in relation to where we are now, I would have hoped that you would have issued an early warning notice. I'm going to say 11th of March, maybe a couple of days afterwards. And then as soon as you realize that this was going to have a direct effect in relation to your site, you get in there with that 61.3 notice, the CEN, the compensation event notification. Okay. Remember, what we have gone through so far, we've concentrated on an unamended NEC3 contract. I'm struggling to think of a job contract that I've worked on where it's been a completely unamended NEC3 contract. Having Z clause amendments are absolutely common on every single NEC contract that I work on, and equally works information requirements as well. You have got to review your contracts carefully. One of the other directors within our Northwest office has been dealing with one particular contractor. They had 48 separate contracts ongoing, and they've had to check each and every contract in relation to the Z clauses that exist to make sure that they've actually given the right notice to the right person on the right timescale and to the right delivery slot, whether that is via the post or via email or even a document management system. what we've looked at is definitely a generic review of the NEC3, and you will need to have a different approach to each and every contract. A couple of other clauses that we can go through fairly quickly now. We've got 62.3. I'm not going to read all of that clause out, but effectively the contractor's got 3 weeks to put together a quotation. I'm going to say that that is going to be hugely difficult. I am obviously watching the press in terms of how long are we going to be on this partial lockdown for? Some of you will be asking your questions on an hourly basis. When will the children go back to school? Is it going to be after Easter? Is it going to be the start of June or July? Or actually, will this continue till September? None of us have got a clue on that. And yet, the NEC contract is expecting you to put together a quotation. And this is where I think we have got a huge problem on the NEC contract. Effectively, a contractor only has one opportunity to put together a quotation. One shot is the phrase that I normally refer to. The project manager should be really proactive here, and the project manager should be instructing the contractor to state assumptions. Okay, so 61.6 in the contract says the project manager, if events are too uncertain to forecast, the project manager states assumptions in the instruction to the contractor when he's asking the contractor to submit quotations. So the project manager should be saying to the contractor now, assume that this event is only going to last 6 weeks, 3 weeks, 12 weeks. And so then the contractor at least can actually formulate the quotation in line with the assumption that's given. However, it is only the project manager that can state assumptions. The contractor cannot invent assumptions on its own. So effectively, the contractor almost has to go to, I won't say quite the most ridiculous degree, but has to make sure that the quote covers all bases. And I have to admit, I would struggle to advise a contractor at this point in time, would you actually take this to September or Christmas? Because we just don't know. We want to be in a situation where the project manager is specifically giving you an assumption for the contractor to include in the quotation. And of course, that cascades down the line to subcontractors as well. That was a whistle-stop tour through some of the clauses that you need to be aware of in relation to the NEC3 contract. I just want to move on now and look at some other bits of advice and some other topic areas that I'm certainly starting now to see questions coming through on. Interim valuations, hugely important area. Lord Denning in 1973, I have to admit, I do not remember him saying this because I was only 1 at the time, but one of his most favourite quotes is, cash flow is the lifeblood of the industry. There is nothing more, more apt to say at this point than his quote. The CLC letter dated the 1st of April 2020 to the to the Prime Minister in relation to an emergency plan quotes a construction industry survey. And this survey was carried out between the 22nd and 26th of March, only in the last few days. And the survey reported the following finding, that 46% of companies would struggle to maintain a viable business if the market remains depressed for more than 3 months. This is an enormous issue. Sika was part of the letter writing committee that wrote to the Prime Minister on this particular issue. I could probably spend a full hour or even more in relation to the interim valuation side, but in brief, how do you maximise your chances of being paid? Number 1, a well-presented and easy to understand application for payment. Number 2, complying with the contract requirements. I've written there the how, the who and the when. How do you have to issue your application? Who do you have to issue it to? And when does it have to be issued by? Make sure that you know exactly what those contract requirements are. Going back to the Construction Act legislation, you must state the sum due and the basis on which this sum is calculated. Your application must be fully particularised, and of course, record keeping is going to be key. Things like photographic records, and actually even, I don't know whether this is the right terminology, I'm still saying video records, but effectively we've all got mobile phones, we've all got the ability to take a quick video of what's going on a particular project. Marked up drawings, obviously making sure that you keep a record of who has marked those drawings up. Contemporaneous, I want these records to be taken at the time that you're putting the valuation together, not a couple of months later. That variations on compensation events are properly priced with all the relevant backup. Yes, you're going to need evidence of materials on site, and I know that unless you've got materials on site as an activity in the activity schedule, you're going to struggle under NEC in getting paid for materials on site. I've also written there, a progress report would be a very good idea. If actually the job has stopped, you want that progress report to be based on the progress on the last day you worked on that particular job. I'm thinking further ahead in relation to this issue, and I'm thinking that some employers on some jobs might decide that if this issue continues, the right way to proceed is actually to terminate the contract. That could be their decision, or it could be because the actual particular employer has become insolvent as well. So you want to make this interim valuation absolutely perfect and detail everything. Pricing new contracts. Not just, however, pricing new contracts, but also the contracts or the quotations that you've given over the last couple of months that are still sat there on employers' desks or on main contractors' desks. We need to think about those in particular. If we think back to early on in today's webinar, I referred to that textbook from 1995 on force majeure, and it used the phrase unforeseen. I think we'd all agree, as at the 2nd of April, coronavirus is absolutely foreseen, although I don't think we quite understand the ramifications of it for us personally or for our companies as yet. But for contracts that you haven't entered into yet, coronavirus is not unforeseen. So one of the jobs I did for a subcontractor, actually it was 2 weeks ago now, this particular guy phoned me up and he said, I'm about to sign a contract, but I'm getting very concerned about the issue of coronavirus. What do I need to do? And I amended this particular contract for him so that in the event that the job did proceed, but it proceeded on a much slower basis, or there was a suspension period, that he was entitled to claim both time and money in relation to the coronavirus issue. Without those specific changes, he wouldn't be able to claim force majeure or prevention at all. So quotations that you have given since, and I'm still struggling with that date, I'm thinking 11th of March, maybe the 16th of March at the very latest, but possibly even January. These quotes have been given in the knowledge of coronavirus, and you would therefore be precluded from claiming prevention or force majeure. Caveating any quotations that you do from now on, checking your terms and conditions, your own terms and conditions, so that if I think of a typical main contractor, you've got potentially your own set of preferred Z clauses up the line. You've got Z clauses down the line to your subbies, and you've got your supply contracts as well. All of those have to be looked at. And also reviewing contracts that you have not yet signed and returned as well. So potentially those that you've sent out and you've got a contract on your desk, all those need to be looked at. A very quick checklist. So some of the issues that I would want you to consider at the moment. And I've already said the first one about 8 times on this particular webinar: review your contracts. Identify which clauses give entitlement to extensions of time and additional cost entitlements. I've specifically split that out here because a very common Z clause amendment to 19.1 and 60.1 brackets 19 is to confirm that actually the contractor can only claim time and not money. So you all need to know what you have signed in the past. Decide what clauses you're going to rely on. Do not jump straight into prevention, force majeure. I've given you some examples of other clauses within NEC that you can look at, project manager's instructions, etc. However, you need to look at your own particular contracts and how they apply in the particular circumstances. Make sure you give the required notices. I'm talking here about the early warning, which is different from the compensation event notice. And I'm also talking about your applications for payment and payment notices as well. Make sure that they are sent using the stated contractual method. Email, post, recorded delivery, hand, document management system. Every contract is different. Get the timing right. Notices normally have to be served in a strict timescale, 61.3, 8 weeks, but often amended down to 4 weeks. Giving the required detail. Sometimes that might mean quoting clause numbers. It might also mean confirming the steps that you're taking to minimize delay as well. And my final main slide here, record keeping. It is hugely important. You need to consider this separately in relation to both time and cost. Now, one of my colleagues, Mike Lynn, has actually produced a really good document on record keeping, and he's split the types of records that he would want to see in relation to time and cost. If you email me after the seminar, either Mike or myself will email you those record keeping documents. And that, Gemma, is me done. Gosh, 54 minutes there, non-stop, not taking a breath. But I can see we have some questions. I'm hoping Gemma is there. No, maybe not. Okay, well, I'm going to have a go at reading these questions myself. So let's see. Don't know whether I can actually bring this. Oh, here we go. Questions. Right, let's see if I can flick this across. Show question list. Here we go. I go to moderated. No, I'm not quite sure whether...
Can you hear me?
I can hear you loud and clear now, Gemma.
Excellent. Yes, the questions I think have come through. They're a little bit long, so they're not popping up on the question mode, but I'll just read them through.
Okay,
so
great.
We have one question. What would happen if a contractor's employees are working from home and a subcontractor submits his notices or applications for payment via post to their office, but there's no one there to pick it up? Is there a risk of a smash and grab adjudication?
Brilliant question, and 100% right. I do not think that there is going to be any kind of, cessation of the possibility of adjudication at all. Yes, if contractors' employees are working from home, as long as the subcontractor does exactly what it says in the contract, gets the applications in, fully particularised, stating the sum due, following those rules that I went through before, checking their contracts very carefully. And if the contractor's employees are working from home, but the contract says that the applications must be sent by post, then yes, the contractor has got a problem there. Of course, there would be nothing to stop the contractor writing to the subcontractor now and saying, I also need your applications by email as well. Of course, that wouldn't be a contractual requirement. I would say most subcontractors probably would comply with that. There is a huge risk of smash and grab. I was on a call earlier with a contractor. They have taken such a surprising action, and they've actually furloughed all of their employees, all of them, including their own QSs. Now, if I was working for a subcontractor and I'd found out that all of the contractor staff had been furloughed, including the QSs, and I'm owed money, then absolutely I would make sure that I am putting in my application properly. And of course, under furlough, as you said at the start, Gemma, you can't work, but you can have training. So actually the contractor's employees couldn't respond to those applications for payment unless they were taken off furlough. So yeah, absolutely huge issue. And contractors and subcontractors, they both have to think about how they are going to manage this through this coronavirus situation. I think the next question down, Gemma, is pretty much the same. Yeah, so the working area. Again, a question that I have seen come up quite a few times as well. As you get into the quantum in relation to schedule of cost components, shorter schedule of cost components, and you're looking specifically at people costs, then yes, of course, this issue of the people have to be working in the working area will come up. Of course, there is nothing to stop a client and a contractor or a contractor and a subcontractor agreeing to extend that working area. That can be done by agreement. And I am aware of at least one client who has done that. However, they still have to prove that they are working as well. Okay, so I'm seeing this potentially more in relation to an option C than an option A situation. It's only going to be done, however, where the client extends the working area. And whilst I've got one example of that, actually, I'm just wondering how many clients will actually extend the working area in this situation. The sitting at home part of the question, I think they will have to prove that they are actually working on that particular project. Otherwise, there will be trouble ahead in terms of the evaluation of the particular issues.
Okay, we have another question coming.
Okay, right. Not NEC, but can a contractor rely on force majeure to close a site to subcontract works despite the potential for updated site operating procedures to mitigate current risks being implemented? So I am aware of a couple of main contractors who've actually taken the decision just to close the site maybe for 48 hours, and we're looking at it being reopened once they've enhanced, I'm going to say particularly the welfare, the canteen, the toileting, hand sanitizers areas, to enable actually a more safer working practice to come into play. Relying on force majeure, it's going to depend on the particular circumstances. So in relation to my scenario there with the 48 hours, I'm going to say probably yes, but it's going to depend on your own contracts. In relation to having to mitigate going forward, I just wonder whether that's possible to actually mitigate to that extent to meet site operating procedures. Remember that site operating procedures are still guidance. They aren't in relation to what the government is putting on the website at the moment. It's still in the guidance category. And remember, we looked at the phrase where possible. So if a contractor or subcontractor said, right, I'm closing the site because of the site operating procedures, I actually would see that the subcontractor potentially would be able to claim not necessarily force majeure, but almost an inability to give access for the subcontractor to do the works. I think that is another pickle of a scenario that people can get into as well. Okay.
Okay, excellent. The only other question we've got a couple more on here.
I can see, Gemma, the one about the slides. Anybody who wants a copy of the slides,
yes.
Again, if they want to email me, I am very happy to send a copy of the slides out to them. I will bring up my email address at the end.
That's fine, yeah. I've also got everyone's contact details, so if they want to get in touch, then I'm quite happy to send a PDF, obviously, of the slides to people.
Okay,
so that's fine.
Great. Okay. Great one. Following on from this topic of post, I ordered some items online recently, and even next day delivery is taking a month to arrive. How would a subcontractor or contractor be affected if notices arrive late through no fault of their own, and how would this be proven? Again, another great question. My Amazon Prime isn't quite being so prime at the moment. A couple of things to think about here. You've got to be able to look at the received. When you're looking at this whole issue of payments, normally it revolves around the word being received. If I was sat there advising a subby against a contractor or a contractor against the client in that particular instance, I would almost go for a belt and braces approach. So absolutely, I would send the application by email. I would also send it by normal post, and I would send it by recorded delivery as well. The view I'm taking on this is actually it's the couriers that are a little bit slower. I'm not really sure how the post is holding up, because as far as I'm aware, the postal system is operating as normal. But I would want to do it on the basis of they've got it by email, they've got it by post, and it's also been sent recorded delivery. So in relation to the notices specifically there, so moving on away from payment and onto the notices, I mean, it's very strict. In the NEC contract, 61.3 talks about this 8-week period, which again is often reduced to 4. The notice has to get there. So again, if you do that by email, post,